and we've all tried to develop Mr. Bradshaw, we tried to develop a plan. So since then, I have engaged some different experts. Thomas Cloud, Gray and Robinson in Orlando, is an amazing utility attorney. Gerald Hartman is an ASA appraiser and an engineer in 31 states. Larry Goldens is a PhD MAI appraiser to do the real property. And William Keith is the same gentleman that ran their tax division for 32 years, who works for me. So that's our team going forward. We're probably going to have a meeting on the 10th, I assume. I understand it's going to be about 10 o'clock. It's going to be a joint meeting between your board and the BOCC board to discuss a budget to fight this litigation. By then, I hope to have some estimates from these professionals, and I'm happy to answer any questions.
Board members.
Mr. Green, you said you negotiated with them every year their assessment.
Yes.
So what was in percentage that they would see a reduction in their, I guess the initial assessment would be at a certain level, and they would negotiate it down to another level?
We don't negotiate a number, we negotiate methodologies. In other words, they may want to use a little different cap rate than we do. We might want to use the cost approach, a little higher percentage than the income approach. So it's all subject. I mean, appraisal is a very subject thing. So we openly listen to them, and they listen to us, and we would arrive at a methodology, and that methodology would create the value. The value times the millage that you all said creates the tax bill. All I do is value.
Okay, so it's kind of like doing it backwards, I guess, trying to figure out where they want to end up.
Well, no, they have an opinion of value,
Right.
and we differ.
But they know what it is that their assessment wants.
Well, this is the first year, and this is very telling also, that we haven't, from day one with Duke, when they did the merger, from day one, they have not called us and talked to us about value. They're calling us talking about tax bill. And I can't negotiate a tax bill. I don't have the authority. I can only negotiate the value. Les, please.
One of the things you need to understand about the valuation is that when they file their tangible tax return each year, they include an analysis of value with that tax return. And for the last several years, that analysis of value has been well beneath ours. And as the investment in pollution control grew into the billions of dollars, that gap got wider. So we have their value, we have the valuation from the expert that we hired. And despite that gap, the prior ownership recognized the local circuit court decision, and they negotiated a value that obviously included a higher than salvage value for pollution control, because that is what separates us. The new ownership that took over decided that they would no longer recognize that local decision concerning the pollution control, and that they seek to have it assessed as salvage value, which is 10% of market value. So it's obvious their plan is to seek to overturn that local ruling or have a new result. Along with that, they strategically delayed conversation from the time the trims went out. They did not have an informal meeting. Hundreds of taxpayers came through our office from mid-August to mid-September. They sat down, they presented data, some got resolutions, some filed petitions with the Value Adjustment Board. Duke did neither one of those things. They asked for records, they contacted us and wanted an informal meeting, and they could not make that meeting till late October. And that was strategic, because at the meeting, Mr. Butler, the last thing he said was, I'm not going to take a token adjustment. We're not going to pay 34, we should be paying 19, and make sure you communicate this to the taxing authorities. I'm going to make a good faith payment of $19 million. He knew exactly what he was doing at that point in time. So there was never a negotiation, there was a demand. That's the thing you have to understand.
And when you say good faith, so people understand what that term means, that's a legal term.
Statutory term.
Yeah. And they decide what the good faith amount is. We don't decide that.
The statute requires them to determine what it is. And they have to have some kind of support for that. If we go down the road and the judge rules in our favor and they have to pay above 1.9, above 19 million, there will be a penalty of interest. The judge can also determine that their payment was not a good faith payment, and it was so flawed that additional penalties can be applied to them by the judge.
And what's the timeline on getting this through the court system?
The legal people we've spoken with say this could be up to a 3-year litigation.
I have a question about when did Duke take over for Progress Energy?
I don't know the exact date.
Along about July is the time frame that I'm trying to remember from reading articles. Yes.
Thank you.
There's another thing that is very telling in this also that Ms. Mays brought up at the meeting this morning, which thank you for that, Rebecca, was they didn't file to go for the Valuation Adjustment Board. Because if you file for the VAB, statutorily you're required to pay 75%. Again, this is all very telling of how this was strategically done, in my opinion. And it's been done in other places, Ohio, and we know some other places.
Mr. Green, if I recall, Duke merged as opposed to simply purchased Progress Energy.
Correct.
Is there anything that in that merger they are assuming the responsibility of the previous findings of the court when it comes to the fact that they had paid this tax bill
Well,
in previous years?
That's a legal help question that maybe Mr. Bradshaw could answer, but I think when they merged, there's a couple of issues. One, there was an increase in the stock price, saying value, and I'm sure that the good faith payment just allows it this year. They'll have to litigate that, if I'm correct, again before Judge Thomas or whoever the judge is. We think it's Judge Thomas. I haven't been served yet, and so that becomes a legal issue.
So each year, though, is
Each
looked
year
at.
stands on its
it
own.
stands on its own.
Yes, sir.
And the same, they could not go back because it stands on its own
Correct.
typically in that year.
That's correct.
Can you maybe also just, I know it's more complex, but the way appraisals are done for a residential home, and not to compare that, but to an ordinary business, utilities are a very complex methodology, if I recall, and you have different methodologies that you have at your disposal in determining that. I believe that's part of what the negotiating was. What options then do, or can you explain maybe that process, since I think right now you've used this particular one?
Right. Well, we still use the 3 approaches to
Okay.
value. But because there's not a lot of utilities selling out there this size, we pretty much rely on the cost approach and the income approach for the most part.
Okay.
And then we put a different weight on each of those approaches, subject to what we think. They do the same. And that's one of the negotiations, give or take. We put 55% to 45, they want to put 45 to 55 on the 2 different approaches. So it's not that big a thing, but it's an issue. Beyond that is the cap rate. We have used the same cap rate for 2009, 10, and 11, and they've agreed upon it. This year they increased the cap rate from 7.32 to 8.66. We don't understand where they're coming from there. They're saying because of risk, but we don't see risk when they go for the PSC and get everything they want. So we think the cap rate should be mid-range, which is the one we've used for the last 3 years and they've agreed upon. Does that help you?
Yeah, it does.
Okay.
Thank you.
But we do use a premier tax consultant, is the name of the company. And like I said, he was head of their tax department for 32 years. He's very specialized in this type of utility and values and approaches. And we weigh very heavily on his recommendation.
Essentially, they're going by new rules, Duke's rules, rather than the rules that Progress Energy.
I don't know what's in their head. We'd have to ask them. I think they just want to increase their bottom line. My personal opinion.
When you look at the good faith payments made, the analysis of the good faith payment, the lowest percentage they made of what they owed was on the units 1, 2, 4, and 5. So it looks very strongly like the pollution control issue is where they're headed. And that would provide them with the biggest adjustment if they were successful.
And in their home area, the pollution control.
Well, Florida's different.
Well, that's what I was going to ask.
Right.
would apply as they see it, or are they're trying to see it Florida's
I
different?
don't know North Carolina law or what the statutes are, but I will tell you that when Ron Schultz litigated this in 1998, PG&E made the full payment. They didn't do a good faith. Again, very telling, I think, of the atmosphere of this company. This is a bully. This is the bully on the playground.
In North Carolina, this property is centrally assessed by the Department of Revenue.
Yes.
It's not assessed by the county property tax.
So, Mr. Green, if I didn't pay my taxes on my house,
Well, first you'd have to make a good faith payment, otherwise you get a tax deed.
okay, so I get a tax deed, then what?
They sell that and they'll pay interest on that.
Mm-hmm.
But it really relates to you telling me you only want to pay $100, take it or leave it.
But after 3 years, you could take my house, couldn't you?
It could be sold on the courthouse.
Mm-hmm. It could be sold.
The filing, the good faith payment and the filing of
Stops.
litigation stops the claim for delinquent taxes.
Mm. Okay.
Because everybody would want those tax deeds. That's why they made the good faith payment.
Mr.
I
Green,
think.
Mrs. Himmel made a comment about that Duke wanted to negotiate with the school board and the Board of County Commission for a $30 million tax payment.
Well, not with me.
Okay, well, I know that,
Not
but
with me. The only offer I've been given is $27 million this year, $24 million next year. Now, we had lots of people, and I'm dealing with the gentleman that can make the decision in North Carolina. His name is Keith Butler, Senior VP of Tax. But we've got people in Florida, PR people for PG&E and other people that will run around and get anybody's ear they can and try to negotiate. But they don't have the power to settle it. So I'm stuck with the main guy at Duke, and that's the largest offer I've had was 27 this year, 24 next year, and we're going to move towards 19. Now, who's been talking to other people? I don't know. I know that there was a meeting. I wasn't at that meeting.
and this question only is for Mr. Blackman, and it's more for the public instead of us, but we're very different from the Board of County Commissioners in that we don't set our millage. The state sets our millage based on the certified tax roll, and they determine what the differential is between what we raise locally and what the schools need, and then they determine how much money they supply us to make the difference. So the fact that this has already been on the tax rolls at a certain value, we have no ability to change our millage rate. We have no ability to change the tax rate for the next year. And had we known about this before the budget ended in legislation, we could have had the state of Florida would have then had to provide to us the difference in funds. But that's not an option any longer.
That's correct. And
So basically,
that's why they strategically waited until this tax roll was certified.
it's kind of like, I use the word blackmail loosely, but
I use extortion.
okay, it's the same thing. You don't play ball our way, we'll put you out of business. We'll put your schools out of business. We'll put your police out of business.
And that's why
Fire,
that's why I wanted to share that strategic timeline, because that's extremely important. This was calculated. This was calculated.
Another thing that I'm aware of is that we often run into situations where people claim there's been an error on the tax roll, and we have to send refund requests to the Department of Revenue. And when they look at a request and they deem that that's a judgment situation, they send us back a letter to the tax collector that says, I'm sorry, but we cannot approve this refund because there's case law out there that says once the property appraiser has rendered his appraisal judgment and the roll has been certified, then he no longer can revisit that judgment. In other words, it's going to take a court of competent jurisdiction to make an adjusted value. So in some cases, once the roll was certified, there can be an argument made that it had already left the property appraiser's hands and it had already moved to the fact that the courts now are the only ones that can actually force or order an agreement. Even though they came wanting to negotiate taxes, it doesn't seem appropriate from what I've read concerning the case law and the judgment of the property appraiser after October 2nd.
And where would that court be? We've already had a judgment in Citrus County.
Well, they'll have to redo it in Citrus.
Is
They'll have to retry it in Citrus, then it'll go to the 5th District, then it'll go to the Supreme Court.
You know, Commissioner Kenny said earlier today, and you repeated it earlier, Duke's actions are that of being a bully. And we're pretty familiar with what it's like to deal with bullies. In fact, we have a policy. And that is that there's going to be some serious consequences. And I will tell you that this board member is very much willing to sit down with the commission and look at what our options are to deal with this bully.
And I agree with Mr. Kennedy, and we need to do this quickly.
Excuse me?
We need to do this quickly.
It can't be done quickly. The quickest we can do is have a meeting on the 10th, and then turn it over to our attorneys and special consultants.
So I need to say to our attorney, we want this done quickly.
Well, we have the meeting tentatively set for 10 o'clock on the 10th. Thank you, Brad. And it'll be at the college, 10 o'clock, CFCC. And I'll be there. We'll all be there. And we'll lay the options out on the table. And by then, I'm hopeful that I'll have some budgets,
Thank you.
hard numbers that we can wrap our heads around. Because this is going to be expensive.
Thank you, Mr. Green.
You're quite welcome. Yes, ma'am. Yes, ma'am.
With regards, I'm sorry, with regards to the fact that they seem to be reducing the amount of tax that they want to pay based on the salvage value of the equipment that is in number 3.
It's the scrubbers and all the 4 and 5.
Scrubbers in 4 and 5.
Right.
So in other words, they're saying that those scrubbers have basically
No.
lived their,
No.
Okay.
They live their life. They're saying there's a statute out there that says pollution control will be salvaged at, or will be valued at salvage value, 10%. There's no definition of salvage value, but nevertheless, they want 10%. But there's only 4 exemptions in the Constitution. There's not one for pollution control. So the court was tried on the unconstitutionality of this issue, and the judge ruled in Ron Schultz's favor.
okay.
So in 1998 to now, that ruling is still sitting there. And if I wanted to get to their 19 million, quite frankly, I could lower their valuation to the point that I would be going against that judge's action. I can't do that.
I understand now. Okay, I was misinterpreting the
That's okay.
salvage value to begin with from a fixed asset standpoint. So I appreciate
And
that.
if you think about it, if you look at 1 and 2 plan out there, the older ones, we've got very little value on those because of that depreciation in age.
Yeah, it sounds like you've been very fair over the years, almost
I
too
think-
fair.
I think we have.
Mr. Green, before you leave the podium, I do want to have a little conversation about the $30 million, because that has been asked by people to us. Would it have been better to take the $30 million? Well, we go back again that we are not the negotiators,
Right.
and we don't have that power to accept that. And that we've tried to explain to people that if Mr. Green had accepted that $30 million, our budget, county budget, is still in a deficit of $6 million.
Your only
And
recourse is.
we're back where we were next year at the same place because nothing's been resolved. So the big question is, or the big concern is, through all this litigation, the assessment needs to be set, everybody, and then the courts need to determine that, and then we set our budgets accordingly.
Correct. And for 2013, I'm bringing in a team, the best I can find, to establish that value going forward. And for all I know, it could be undervalued right now. So let's roll the dice and see.
How else could Progress Energy or Duke have handled this? And other than
Well, when they got their trim notice, they could have called and had an informal conference like everybody else does. They could have filed before the Valuation Adjustment Board, special magistrate, for a ruling. But if they still weren't happy, we're still back to 60 days from the date of certification, which is next Monday. You have to serve a lawsuit.
Okay, so that was their only avenues.
Well, that's their only avenues, but they still could have negotiated the value. Go ahead, Russ.
If they had filed a value adjustment board petition, and that took a couple of months to hear, that would have extended the time for them to file litigation that would have pushed that on into the spring. So they would have gained time to meet and negotiate and have conversation, and that would have pushed it on into the spring. My understanding from talking with them is they don't go to the Value Adjustment Board because they believe that is beneath them, that forum. So,
Well, we also sit on the value adjustment board.
But so in one,
That's what they think about you.
and in one sense, they want to say they are an ordinary property taxpayer, but they're too good to come to the Value Adjustment Board.
This is tangible tax too, isn't this all tangible tax that we're talking about?
Most of it.
there's some
There's some real.
Yeah.
Yeah.
But most of it
Yeah.
is.
There's the site out there, the physical site. You know. And there's 185 parcels through the county they own. They made a good faith reduced payment on 9 parcels.
They accepted 176.
They were just not the valuable ones, unfortunately.
It's all strategic.
Yeah. However, we believe going into 2013 that we ought to take a good look at all 185.
Including the port.
Thank you, Mr. Green. I'd like to ask Mr. Blocker if he would come forward now and discuss with us the impact this might have on our budget.
Yes, ma'am. Currently, as Mr. Green indicated, the reduced payment affects us by approximately $8 million. If you break that down for our budget, that's about $6 million for the general fund and $2 million for the capital fund. So we've already started exploring ideas within our own budget as to how to postpone capital projects and potentially be able to transfer funds from the capital fund, do an interfund loan to the general fund, be able to pay for the interim the next 6 months to get through this school year. We're also exploring information and talking to individuals up in Tallahassee and DOE to help us explore other avenues that may potentially be able to help us out in this situation. So that's where we're at right now.
If we were able to temporarily transfer funds from capital, which I'm not even sure what we have in our reserves account.
Well, when we budgeted this past year, we budgeted for an ending fund balance at the end of June 30th for approximately $26 million. So we would have funds to do it. We've already identified projects to postpone or to put off for a while to be able to make up those dollars.
But we'd have to pay ourselves back.
Exactly. You have 13 months per the statute to pay yourself back.
Wow.
So we've looked at it cash flow wise. We would be able to probably go through April or May before we would need that transfer.
Of the, did you say 26 million in our capital?
Fund balance.
The fund balance? But some of that's already, at this point, committed to projects we probably can't stop.
No, the 26 million is the ending fund balance for this year.
It is the ending.
Now, you're thinking the 5-year work plan that has it budgeted out over 5 years.
Okay, that's what I was just going to say. It's encumbered for the 5-year, but not for the current year.
Well, it's planned out. We have major projects that we're planning.
That's correct.
Renovations and buses.
So we would need to look and see, we need to prioritize, because our priority right now is to make it through this year in the operations of the school district.
And how much money have we lost in capital over the last 3 or 4 years from budget cuts from the state?
Oh, we're upwards in the capital just in itself for the last 3 years, probably in the tune of 25 million, and operating we're down 15 million in the general fund. So we're probably 40 million plus.
And I think we have to again say, we have lost $40 million in funding over about what period of time?
3 or 4 years.
That's what I thought.
Yes, as I was listening to the county commission earlier today when they had their meeting, they were talking about some of the projects or the areas they might have to make cuts in. And many of them that you brought up were areas that it's mutual use. We also use those same areas. So if you shut this down, you shut down part of the programs that we're doing too. We're tied together. And while you were talking, I was thinking of Duke Energy. I thought, it's December tomorrow. This is the Grinch who stole Christmas.
Mr. Green, the tax bill is really not essentially due until March 30th?
November early payment, that's why they paid the last week to take the 4% good early payment.
But is it possible that they could have a change of heart and still pay?
Anything can be negotiated. My door is wide open.
But they could file a lawsuit.
Yeah, but what I'm saying is.
But it is still, actually, that makes it easier to settle.
Okay.
But that's not my point. My point is that the tax in reality is not essentially completely due until March. So it's not overdue. They're not
Well, you get different discounts if you pay early.
I understand
So,
that, but it's not like we're saying they missed the deadline and now there was no turning back. They have until March essentially to pay that if they chose to,
Or beyond. I mean, they can,
well, without further penalty.
thank you.
Thank you. Mr. Thorpe, would you come forward, please? Thank you.
Thank you for inviting us here.
You're very welcome.
Appreciate that. What would you like to ask?
I'd like to know about our meeting. I'd like for you to tell us about our meeting we're going to have.
Well, I'd like to inform you that we're asking for this board to meet with the Board of County Commissioners on December 10th. That would be a day meeting. We thought that's the only available time at CF for a meeting. And the room is large enough to hopefully to hold all the audience that will be there. But we need to invite the other taxing authorities. SWIFMUD, Hospital Board, Mosquito Control Board. They need to be there, and my suggestion would be, and it's up to these two boards, but we probably, since we're both the biggest receiver of the taxes, that these two boards meet. We invite the others to be there in the audience, because I don't know if we have enough room on the dais for every single person on every taxing authority. So what we will do is invite all of them there. They will probably send representatives or spokespersons, and they can interface with you at that meeting at a microphone. And then we can decide, the strategy there is decide for what to go forward with for a legal strategy and how to pay for it.
And I also plan to have all those experts at that meeting, so you can talk to them yourselves. The attorneys, the appraisers, the engineers, everybody. I'm going to do my best to get them there.
Thank you. Thank you very much.
Thank you.
You need a motion?
Do I need a motion? Yes, I need a motion.
I'd like to make a motion that this board accepts the invitation and attends the December 10th at 10 a.m. meeting at Central Florida College.
I'd like to second.
I'm sorry?
We have a motion by Mr. Kennedy and a second by Ms. Powers. Do we have any discussion?
I'd ask you to amend your motion. It's not that we attend that meeting, it's that you said that you're going to hold a special meeting with the Board of County Commissioners.
I amended to that we will hold a special meeting with the Board of County Commissioners and any other taxing authority. If you notice her hand sometimes is right.
We have a motion, we have a second. Do we have any further discussion? All those in favor? Aye. Motion carries 5-0. Mr. Bradshaw, you're up.
I was just going to cover a few things, but I think that Mr. Green covered some of them while he was at the podium, and the fact now that a lawsuit has been filed kind of shortcut a lot of what I was going to tell you about what the statute said and the procedures that they had to go through. Whether they filed their suit time or not will be something for the other attorneys to discuss. It's my understanding that the property appraiser, the tax collector, and also, let's see, the Department of Revenue was also, named as defendants in the lawsuit. And Mr. Green was correct, and there's the Supreme Court case that talks about not being able to challenge the constitutionality of the statute, and that's why they are seeking, a taxing authority to come in as an intervener in the matter. One of the things I will tell you, and Mr. Wesch this morning at the Board of County Commissioner meeting informed us, was that when speaking to outside counsel, they estimate like the net present value over the next 30 years to be a loss of $330 million to the county, if they're allowed to reduce their taxes to that amount. So I'm glad that y'all agreed to have a joint meeting with the Board of County Commissioners, and then at that point in time we can discuss how you want to proceed as far as the joining of the lawsuit and then the funding of the lawsuit and those types of issues. So thank you.
Thank you. All right. We have Jimmy Smith here now. Representative, thank you for coming. All right. Without any further ado, do I hear a motion for adjournment? So we're adjourned. Thank you.
See you around.
All right, this is Monday.